Hi, my name's Isaac Shutt. I'm a wills and trust and probate attorney based in Texas. Today, I'm going to talk about one of the most basic questions that comes across my desk all the time, and that is, what are the will requirements in the state of Texas? Now, specifically today, we're going to be talking about what are the requirements for a typed will. I've already made another video about how to make a handwritten or holographic will. Those have their own requirements, but today we're talking about a typed will. So without further ado, let's jump into it. Number one, as you might have already expected, the first requirement is that it be written. In order for a will to be valid in Texas, it has to be in writing. And I know that seems obvious, but listen, all the time people come to our office and say, you know what, my mom just passed away, but she told everybody she wanted me to have her house. Now, she doesn't have a will that says that, but she told everybody she wanted me to have her house. So the fact that she made those oral statements are really not helping. They're not counting as a will because under Texas law, there's no such thing as an oral will. It has to be actual on paper in writing in order for it to be a will. Number two, here's another obvious one. Intent. It has to be obvious from the document that the person who's making the document intends it as her will. So again, to use the example of mom giving away her house, if she says just on a piece of paper, I want my daughter to have my house. Well, that statement in and of itself doesn't make it obvious that mom is making her will. She could mean, I just sort of want her to have it, or I want to give it to her now. It's not obvious from the document that she actually intends it as her last will and testament. Now, when our law office does wills, we almost get a little silly with this. We use the old English font at the top and it says last will and testament. That way there's no mistaking what that document is. It is clearly intended as a last will and testament. So the next requirement for a will in Texas is that the document be signed. So if you type out a will but you fail to sign it, it cannot be probated as a will after you pass away. So it is an absolute hard requirement in Texas for a will to be valid that it be signed by the testator. And if we're talking about typed wills, the next requirement is that it be witnessed by not one but two witnesses. So when you sign, you must sign in the presence of not one but two witnesses. Now again, I know some of this seems like common sense, but a lot of people think that they need three witnesses or one witness will count. No, you have to have two witnesses in your presence when you sign the will. Now, that is the hard, absolute must in the will, but there are some other things sort of outside the document itself that are really important. One is you have to have soundness of mind. So you actually have to understand what you're doing. And there's more specific requirements, and maybe I'll make another video about what soundness of mind for a will in Texas is, but it is a requirement that the testator have soundness of mind. The testator also has to be at least age 18 at the time the will is signed, and the witnesses have to be at least age 14 at the time the will was signed. Now, those are the hard requirements for a will, but most of the wills that you're going to get from an estate planning law office are going to be what we call self-proved wills. And that means they have a self-proving affidavit. So after the signature page that has the testator's signature and the two witnesses' signature, there's usually going to be an affidavit that says self-proving affidavit at the top. And it's going to have sort of a paragraph listing a number of facts, like testator was at least age 18, the witnesses were at least age 14, the testator had soundness of mind, and that everybody signed together. Now, by taking down that paragraph, basically what we're doing is taking all of the written testimony that those witnesses would have been required to give in court after the testator's death. So if you don't have that self-proving affidavit, guess what? You're supposed to track down the 2 will witnesses, haul them into court so that they can raise their right hand and tell the judge what they observed at the time the will was signed. So it's really important to have a self-proving affidavit so that you have a self-proved will, so that after you pass away, we don't have to go wrangle up those witnesses. I've done that. It's really hard. When we see a lot of these like online or DIY wills, they're missing valid self-proving affidavits, which means I have to go track down some poor Kinko's employee from years ago who was a teenager at the time and now has a full-time job somewhere. They're hard to find, so be sure to have a self-proving affidavit. Now, if you're going to have that self-proving affidavit, that needs not only the signature of the testator and the 2 witnesses, but now we add the requirement of a notary. So to have a valid self-proved will, the will in Texas has to be notarized. Now, if you're not going to have a self-proved will, if you're in a big hurry, you don't have time to get a self-proved will, you can have a notary as one of your witnesses, but you don't need to have 2 witnesses and a notary if the will's not self-proved. If it's self-proved, we're adding the requirement of notarization on there as well. I hope you found this video helpful. I will tell you that we see a lot of do-it-yourself wills or online wills that really don't pass muster under Texas law. You know, this is one of those situations where you really should take the time and invest a little bit to maybe have an attorney help you with this. And that's not to belittle you at all. Keep in mind, a lot of our business actually comes from referrals from other attorneys. That means even other Texas attorneys are afraid of messing up a person's will. And so we actually get referrals from other attorneys to make sure that all of these requirements are met, because it's so important that it be done correctly. I'm always concerned that people think they have a valid will when they actually don't, and then their family is in a world of hurt when that person passes away. So take the time to at least consult with an estate planning attorney to do even a basic will. And again, my name's Isaac Shutt. I'm of the Shutt Law Firm. Our office is in Texas, and today's video has been about the requirements of a will in Texas.